Are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Miss Evans is currently on probation for a lesser offense of terroristic threat against.
Right out of the gate, she's already on probation for terroristic threat against a public servant. That's serious. When you're on probation, the court is basically giving you a second chance instead of jail. But here's the catch. That second chance comes with strict conditions. One slip can reopen the entire case.
A public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor. I have no, Your Honor.
I'm sorry, Your Honor.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead. The battery's been dead for 3 days.
Okay.
At this point.
Okay. Thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does consider maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right? I mean, it says right here she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which deed, Ms. Harris? What do you want?
If I can do the 60 days that they offer me and be off
Well,
probation.
60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me.
This is a turning point. She's essentially saying, let me just serve time and be done. Some defendants prefer short-term certainty over long-term supervision, but probation is designed to keep people out of jail. The question is she overwhelmed or just unwilling to comply?
To sentence you today.
Yeah,
So,
okay, so
what?
I'll have to be reinstated.
Okay,
It is a misdemeanor, you know, isn't it?
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. Obviously, probation is a system designed to try to keep people out of the actual criminal justice system in the future and avoid incarceration. So, just looking at this, since it is just a misdemeanor, I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued. Follow the maybe the recommendation, you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are for the mental health state.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know. I didn't see anything.
Whoa, did defense counsel just float a possible antisocial personality diagnosis without documentation? Judges rely on evaluations, not speculation. In court, you can't casually attach a DSM label unless it's supported. That moment right there, risky.
Thing where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there.
Okay.
Obviously, things that can be dealt with.
Judge, I think incorrigible and defiant means she doesn't want to do probation. It doesn't mean you can tell her what you can and can't do. I'd ask that we revoke her.
So, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were tested positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission.
Listen to that list. Failed groups, positive tests, left the state, fake sponsor, zero tolerance violations. In probation hearings, judges look for patterns, and once a pattern of defiance forms, it becomes less about one mistake and more about overall accountability. At this point, mercy starts shrinking.
I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you, ma'am.
Can I get my phone, my sister?
Talk to the bailiff. Just talk to the bailiff. Yeah. Give me just a second, Mr. Gross. So, you were late this morning, Mr. Gross.
Yeah, I'm not at the garage like 45 years. My bad.
Okay. So, probation sent me over an administrative hearing showing that you had failed to report twice in August and then again in December, that you weren't working and giving proof of that you're behind in your community service, that you didn't take the defensive driving course yet, that you did not complete the psychological evaluation so that we could figure out what, if any, tools, so we could figure out what, if anything, you need to be successful on probation. So let's start there, because I think that's probably one of the most important parts of it, is why haven't you done that evaluation yet? You're not going to be able to help her if you're in prison, are you? Okay, so you have to do your probation no matter what. That's not an excuse, and I won't take that as an excuse. You can make an appointment. You're going to get that evaluation done within the next 2 weeks, or I'm asking them to file a motion to revoke your probation. It's that simple. 2 weeks. 2 weeks to get the evaluation done. If you're not working, you should be doing community service every single week.
How many months or days have you been on the county for this charge?
It's not a county case, it's a felony. So here's what you're charged with: the state jail felony offense of evading arrest or detention with previous convictions. And so if you don't want to be on probation, then they can file a motion to revoke. They have enough here to revoke your probation. But why wouldn't you want to just, you don't want to go to state jail prison, do you?
It's too much.
But you're going to be away from your family for some amount of time if you get revoked.
How many
I don't know. We're not here I don't do the negotiations. So if you want to have your probation revoked, what would happen is a motion would be filed. There would be a warrant for your arrest. You would get in custody. We would appoint you a lawyer. That lawyer would talk to Ms. Malfino. They would discuss what your violations are, what they think might be a fair punishment. We would come to court. If I think it's a fair punishment and agree with them, I would give it to you, and you would go do whatever time that is. it's not gonna, I would assume it wouldn't be the whole 2 years, but I don't know right now. I don't remember what your criminal history was, other than I know you got, hold on a second.
Definitely not gonna count.
Yeah, so, I mean, you know what a 1244 is? Okay, well, what a 1244 is, a lot of people think if they get a state jail prison time, there is a way that you can do county jail time in some cases on that, and what she's saying is it's not going to be county jail time. It will be some amount of state jail time.
This is where the stakes get real. He's charged with a state jail felony, and the judge just clarified something important. This wouldn't be county time, it would be state jail. That's a different level. He keeps asking how many months, but sentencing after revocation isn't a simple menu choice. It depends on negotiation and judicial discretion. And that uncertainty, that's the gamble.
So you don't want to get the help with probation? You want to...
It's too much, man.
All right, well, I don't know that. That I'd let you go today then. Have there been any issues with drug use? Any talk? No positives. How quickly can y'all get that done? What's your position with regard to where we stand right now? I mean, we've got violations, obviously. If he doesn't want to go do those things, I know.
It seems a shame.
I don't disagree.
Not for me to decide. I know this where we'd be willing to work with him. I know he says it's a lot. I know there are specialized cases that maybe help him get on track. I know that's what we're going to work for.
You don't want to think about it for...
Like, how many months or days?
I don't know. That's the thing. I just told you. We just went through that. All right, then at this time, what I'm going to do, unfortunately, Mr. Gross, is because of those violations of your probation that you already have, at this point, I'm going to order as a condition of probation, because you're still on probation, that you serve 20 days up front time. You'll go into custody today. That'll give the state time to get that motion to revoke filed. You'll get credit for the time that you're sitting, but I'm not going to let you go today and possibly do something else that you're not supposed to do while you're on probation.
And there it is, 20 days upfront time. Not a full revocation, but not freedom either. The judge is buying time while protecting the community and the record. This was a crossroads moment. Help was on the table. The real question for you watching, when the court offers structure instead of prison, is that mercy or pressure? And what would you choose?
So you can go back with the bailiff.
And there it is, a harsh reminder that choices have consequences. In this courtroom, we saw opportunity meet defiance, the chance to change, to comply, to move forward, met with hesitation, excuses, and missed deadlines. Every test missed, every rule ignored, stacked like bricks against freedom. Yet, beneath the violations, there's a human story, struggles, mental health, personal hardship, realities that often go unseen. The judge weighed mercy and accountability, offered a path to rehabilitation, but the path demands courage and responsibility. In the end, it's a reflection for all of us. Will we learn from guidance or wait for consequences to teach the lesson instead? That's the quiet question lingering after the gavel falls.